There can be few people within this sphere of the internet that has not by now heard of the arrest and imprisonment of Tommy Robinson. Due to the ill-advised court restrictions on reporting, confusion and misinformation prevailed after his arrest during an internet livestream. Worse, many pundits on the left pounced gleefully on the inevitable speculation as being ill-informed or simply an exhibition of idiocy. A notable contribution to this toxic atmosphere was the article by the secret barrister, who described those incensed at the perceived injustice as, and I quote, knuckle-draggers, and the impromptu march on Downing Street as, and I kid you not, a Nazi-themed march. So at least in some circles, a few Union flags and a middle-aged woman holding Free Tommy placard are equivalent to the Nuremberg rally. It's interesting, isn't it, to contrast the simple statements relating to points of law contained within this article with the unguarded comments that provide a window into the character of the author himself, who reveals himself as a sneering and highly politicised creature with an ill-disguised contempt of those he feels less worthy than himself. The media, desperate to spin the narrative, have embraced both the tone and the content of this and similar articles. The public's lack of understanding of the law and how it works only aggravates the issue, as does the subtle differences between the UK and the US legal systems. Americans in particular struggle to understand how on earth such a situation might arise. How can it be that Tommy Robinson, having been arrested on an imaginary breach of the peace charge, can within hours be convicted for contempt of court for simply reporting on the mere existence of a court case? Add to this the dismay and disappointment felt by some on learning after the restriction on reporting was lifted that Robinson had pleaded guilty. All of these things, the points of law, the prevailing political environment, and the admission of guilt should be considered carefully. And the first point I would make is a simple one. If you believe that all those who have pleaded guilty or have been found guilty or confessed to a crime are in fact guilty, then you have a somewhat naive view of the judicial process. But the fact remains that once the defendant has admitted guilt, whether freely or on the advice of counsel, that places them in an extremely difficult position, legally. Most people have focused on the incredible speed in which this matter was dealt with, and that is a very real concern. Many have commented that there were only a few hours between the arrest and sentencing, but it's actually worse than it first appears, because if you view the actual court records for that day, we see that initially the case was in adjournment between 12:30 and 2 o'clock, and the matter was decided in just 20 minutes. The case was actually closed at 2:26. Even with an admission of guilt, that seems a woefully inadequate amount of time for his defence to plead mitigation, and the live stream itself, which was over an hour, formed the basis for the contempt, which could not have been viewed in its entirety. The next point we consider is the theory that judges cannot be both witness to a crime and then sit in judgment on that crime. It seems, if reports are correct, that the judge in this instance actually watched the arrest from the court buildings. But this seems to overlook the fact that in relation to matters of contempt, the judge is always a witness in his own court, so I doubt if that particular theory has any basis in law. I watched the full live stream of Tommy outside the courts in Leeds, all 1 hour and 15 minutes of it. I did so assuming his guilt and with the intent of finding the actions on his part that would amount to contempt in this instance, being mindful that the previous finding for contempt is irrelevant at this stage. There were 2 points in the live stream that might be considered contempt. At one point he listed the offences for particular defendants, and while these were a matter of public record, some of the offences he listed had actually been dropped, so this might be considered as accusing those defendants of crimes for which they were not being tried.
Today are called Mohammed. The defendants today, Mansour Akhtar. He's charged with trafficking. Mohammed Akram. He is charged with Wikas Mahmud.
The second point was when he approached the accused and asked them how they felt about the impending verdict. This might be considered as hindering or harassing behaviour of the accused as they entered the court. Both these issues seem to me as technical. The first is a simple error which I think most journalists have made, that of assuming that the accused are being tried for all charges previously listed. The second, however, is problematic because the law is quite clear in this regard, even though it is often only selectively applied. You cannot harass any party to the court proceedings within the precincts of the court. Note the term precinct. This is not the same as grounds or property. Precinct is a more vague and ill-defined term. However, in the live stream, Tommy Robinson can be heard clearly asking a police officer if it was permitted to film where he was filming, and the officer acknowledged that it was permitted.
Officer, are these stairs? So if you're not allowed to go on those stairs, am I? Whilst recording.
As long as you're respectful.
This isn't the property of the court, though, is it? No, is this? Okay, so I'll stay off then. Cool.
So a reasonable person would have to conclude that the police officer considered the area within which Robinson was filming as not part of the court precinct. Another issue of concern is the initial charge of breach of the peace. Police often use public order offences to hold a suspect while they investigate or gather evidence for other, probably more serious charges. But there's a problem with this in the Tommy Robinson case because, quite clearly, there was no breach of the peace, and breach of the peace is a common law offence. It's covered by the Criminal Evidence Act 1984, Section 24, which applies in this scenario. An officer can only arrest somebody when he has reasonable grounds for suspecting them to have committed an offence, or is likely to commit an offence. That clearly was not the case, as Tommy Robinson had not threatened anyone with violence. In fact, he was shoved by one person and actually received a death threat, and the police present were simply not interested. Tommy most certainly did not try to retaliate when provoked, so the breach of the peace arrest was most certainly a holding charge. But there lay another issue. It is unclear whether a police officer can be instructed by a third party to arrest somebody for breach of the peace that the third party had not witnessed. That would seem to me something only the arresting officer could possibly determine. Unfortunately, even if the initial arrest was suspect or even unlawful, this does not mean that the contempt charge or conviction is somehow invalid. It will still stand, as unfair as this might seem. The law has the weight of the state standing behind it, and while technicalities might be used to prosecute, they are less effective in defence, particularly when produced in a hostile court. Another issue that we might consider is the claim that Robinson's conduct would affect the outcome or even cause a retrial. This claim has been made in many articles and even by the judge in this case, but it is patent nonsense. The accused was attending Leeds Crown Court on that day to hear the verdict of their peers. The trial was effectively at its conclusion. The jury had already deliberated. Nothing Robinson would have said on that day could have had any influence on the outcome. To suggest otherwise is baloney. Even if this were not the case, and Robinson would have announced their guilt by megaphone for all and sundry, would not the jury have had to listen to the prosecution make the exact same point? The only difference being that the prosecution would have whatever evidence had been gathered by the investigating authorities and would be able to make the accusation in a more erudite and elegant manner. And do we trust these members of the jury to be able to make the distinction between the two? Of course, the defence will grasp at any opportunity to make a point of law or to capitalise on technicalities. That is their job. But do we now overturn verdicts in the Moores murder case or the Bulger case, both of which were highly publicised and hardly short of howling mobs and media coverage? Of course not. No one with any common sense would believe that the juries in those cases took their duty less seriously than the people in powdered wigs. Now let's contemplate for a moment. There were 27 men and 2 women accused of grooming girls, some as young as 11 years old, and it has taken many years to get the authorities to even acknowledge the existence of Pakistani rape gangs, let alone bring the alleged perpetrators before the courts. A situation that for many years Robinson had tried to raise awareness of, at great cost to himself. For years he had been accused of racism and bigotry for even suggesting such a thing as rape gangs, Yet here we are, the same man arrested, put before a judge and sentenced to prison in less than 4 hours. How can that ever be justified as being right? I'm not talking legalities here. The question I'm asking is, does the punishment even remotely fit the crime? Is it right? Is it just? That's the question I'm asking. It has also been said that his solicitor was told he had been released, and so it may also be the case that regardless of how well qualified or experienced his court-appointed barrister was on that day, he never had an effective defence. His court-appointed barrister had little time to make a considered opinion. In fact, it would appear from court documents that his defence had less than a couple of hours. As already mentioned, the live stream itself was 1¼ hours in length. Does anyone seriously believe that Robinson's defence had adequate time to prepare? This would put a drumhead court to shame. And what of Robinson? He is a working-class man, a citizen journalist without the benefit of formal training. He would have had to rely on those he perceived as acting in his best interests. If you attempted to conclude that he could have dismissed any advice, which is true, consider his background and then tell me he should have done X or he should have done Y. Tommy Robinson certainly did not seem to do anything grievous in his live stream that I could see. In fact, he seemed to take some care in his use of words. But maybe he was not careful enough. It might be possible that in law he had technically been in contempt of court. There was certainly nothing to suggest that anything Tommy was doing outside of the court grounds could have come to even close to prejudicing or impeding the case. As I have already indicated, the case had been concluded, and it was simply a sentencing court. We will have to wait and see what is contained in the judgment once the other grooming case has been concluded. But it seems to me Tommy Robinson's rights under Article 5, 10 and 11 of ECHR have most certainly been breached. I suspect that his initial pleading, if taken on advice, was in error. It may take weeks before his legal team can prepare a legal redress, and it's uncertain what options are available to them at this point. Any reasonable person would have to be concerned about the facts of this case. It would be a very worrying state of affairs indeed if the judiciary were freely able to use contempt to unlawfully silence those who were perceived as troublesome. The arrest and imprisonment of Tommy Robinson has been well received in some quarters, but as bothersome as he might be to some people, he is not the real problem here. And we all know it. The real problem is still with us. It has not gone away, nor will it anytime soon, because they simply have no plan for making it go away. But the one thing they can do, with impressive alacrity, is to imprison a boy from Luton. We end our adventure at this point. I hope you found something of interest in this video. If you would like to support my channel, I now have a Patreon page. If you're unable to support my work from Patreon, then you can share, like or comment. It's all good. Thank you for watching.